Good evening, and welcome to the William G. McGowan Theater here at the National Archives. I'm David Ferriero, the Archivist of the United States, and I'm pleased to welcome you this evening. A special welcome to those who are joining us on YouTube. The 14th Amendment spells out key protections that we now consider basic rights, notably due process and equal protection under the law. Since the passage of the amendment shortly after the end of the Civil War, the courts have looked to the 14th Amendment when deciding many landmark cases in matters of liberty and equality. Our partner for tonight's examination of the 14th Amendment, Shield of National Protection, a constitutional guarantee of liberty and equality, is the Constitutional Accountability Center and the National Constitution Center, and we thank them for their support. Before we begin our panel discussion, though, I'd like to tell you about two other programs coming up next week to commemorate the 75th anniversary of the attack on Pearl Harbor. On Wednesday, December 7th at noon, Craig Nelson, author of Pearl Harbor, From Infamy to Greatness, will tell us about how military personnel, diplomats, the Emperor of Japan, and the President of the United States reacted and fought during this dramatic moment in world history. And later that afternoon at 2 p.m. in a program titled From the Vaults, How Americans First Learned of Pearl Harbor, Mr. Nelson will introduce from our collection radio broadcast, newsreels, and photographs that illustrate how the media kept Americans informed of December 7th, the attack on the naval base at Pearl Harbor, which plunged America into World War II. To learn more about these and all of our public programs and exhibits, consult our monthly calendar of events in print or online. There are copies in the lobby as well as sign-up sheets where you can receive it in regular mail or email. And another way to get more involved in the National Archives is to become a member of the National Archives Foundation. The foundation supports all of our education and outreach activity, and there are applications for membership in the lobby also. And a little known secret that I keep telling everyone about, no one has ever been turned down for membership in the National Archives Foundation. Of all the amendments to the United States Constitution, the 14th is the longest. It contains more words than any other amendment, and its first section alone touches on what we now consider key concepts of liberty and equality. Historian Jack Rakoff has noted that none of the constitutional provisions adopted since 1789 has done more to shape and define the concept of a more perfect union than Section 1 of the 14th Amendment. In fact, there are so many important parts to the 14th Amendment that each of the 5 major parts of Section 1 could merit its own panel discussion. Upstairs in the Lawrence F. O'Brien Gallery, a display case in our Amending America exhibit contains the 14th Amendment itself, along with a selection of documents from Brown versus Board of Education, the decision on school segregation. The 14th Amendment's Equal Protection Clause was the basis for the Supreme Court's 1954 Brown decision, as was the 2015 Obergefell versus Hodges decision, which legalized same-sex marriage. Landmark legislation such as the 1964 Civil Rights Act and the 1965 Voting Rights have also been grounded in the Equal Protection Clause. And it's through the 14th Amendment that the full protection of the Bill of Rights was extended from the federal level to the state level. Questions of liberty, equality, and due process are continually being debated and decided today, and we look forward to an invigorating discussion of these issues tonight. And now I'd like to welcome our first panelist to the stage, Senator Chris Coons, Judge James Wynn, and Jeffrey Rosen. Senator Coons has served as the U.S. Senator representing Delaware since 2010. He serves on the Appropriations, Foreign Relations, Judiciary, Small Business, and Entrepreneurship Committees, and the Select Committee on Ethics. Previously, he was the County Executive of Newcastle County, Delaware. Senator Coons is the 1983 Truman Scholar from Delaware and the first recipient of the award to serve in the United States Senate. Judge Wynn serves on the United States Court of Appeals for the Fourth Circuit. He was nominated by President Obama in November 2009 and confirmed by the Senate on August 5th, 2010. Previously, he served on the North Carolina Court of Appeals and the Supreme Court of North Carolina. Judge Wynn also has served as a certified military trial judge and a captain in the U.S. Navy Reserves and has received numerous medals and commendations. Jeffrey Rosen is the President and Chief Executive Officer of the National Constitution Center. He He's also a professor at George Washington University Law School, a non-resident senior fellow at the Brookings Institute, and a contributing editor for The Atlantic. He's a graduate of Harvard College, Oxford University, where he was a Marshall Scholar, and the Yale Law School. Ladies and gentlemen, please welcome Senator Coons, Judge Wynn, and Jeffrey Rosen.
Thank you so much for that wonderful, comprehensive, and scholarly introduction to the 14th Amendment, and it's so great to be back at the National Archives. Ladies and gentlemen, I'm Jeff Rosen, the head of the National Constitution Center, and Elizabeth Wydra, the head of the Constitutional Accountability Center, and I are so thrilled to be hosting this second founding initiative. You see this beautiful logo behind you. For the next 5 years, we are going to be celebrating the 150th anniversary of the 13th, 14th, and 15th Amendments, which transformed the Constitution after the Civil War and guaranteed the promise of equality that had been in the Declaration of Independence. So tonight we're talking about the 14th Amendment. It's ratified, or rather proposed by Congress in July of 1866, so this is the 150th anniversary year. Last year, we were here with Judge Wynn to talk about the 150th anniversary of the 13th Amendment, which was ratified on December 6th. So here's what happens between December 6th, 65 and July of 66, and then I'm going to ask our incredible panelists about their thoughts on this history. The 13th Amendment is passed. Congress passes the Civil Rights Act of 1866, which guarantees equal civil rights to all persons, regardless of race. But Andrew Johnson vetoes the Civil Rights Act on the grounds that Congress doesn't have the constitutional authority to pass it. Congress overrides Johnson's veto, but just to be extra sure and to make clear Congress's authority to pass the Civil Rights Act of 1866, it proposes the 14th Amendment in July of 1866. And now we have to read the text of the 14th Amendment, and we have two places to do that. We can either look at the wonderful National Constitution Center Pocket Constitution, or even better, because I'm a constitutional traveling salesman, you can take out your iPhones and look at the thrilling interactive Constitution of the National Constitution Center, which is so useful that you can even use it when there's no Wi-Fi or cellular access in a place like this, because it's an app called the Interactive Constitution that I want you all to download, not now because you can't unless you have Wi-Fi, but later on. And here you will find the leading liberal and conservative scholars in America writing about every clause of the Constitution, describing what they agree about and what they disagree about. This has gotten 8 million hits since it launched a year ago. It is a constitutional feast, and you will learn so much from it. All right, so here's the relevant language. Let's just, you know what, there's so much, as the archivist said, each clause could merit its own passage, but let's focus on the Equal Protection Clause, because that's a good place to start. It says, no state shall make or enforce any law which shall deny to any person within its jurisdiction the equal protection of the law. Judge Wynn. Congress wants to make sure that the Civil Rights Act can be passed. What does equal protection mean? And tell us why the amendment was passed and what the framers were trying to achieve.
Thank you, Jeffrey, for inviting me back. I'm happy to be a part of this panel. I want to start first by indicating you cannot examine this amendment nor any of the other Reconstruction Amendment without considering the historicity and the context in which they were enacted. And when they were enacted correctly, you said that in 1866, the Civil Rights Act came about. But, of course, the great fear, not only did Andrew Johnson veto it and it was overwritten, was that if another majority got into Congress, of course, it would be gone just as much as it was there. So Bingham and others clearly wanted to ensure that those rights would be preserved. I will say equal protection is definitely an important part of this, but in my view, every bone in my body tells me that the Privileges and Immunity Clause was the one that really Congress intended to have the teeth here. And of course, the great court that existed with the slaughterhouse cases virtually eviscerated that, so no need wasting time talking about it here, except maybe the next panel when you get to talk about the McDonald case to some extent. But from the equal protection perspective, it is, of course, the basis for every civil rights case in this country. And I think the importance of it, along with the due process, I don't want to escape that too, clause that's there. The importance of it is to ensure that citizens enjoy the equal protection of the rights. And that has been the basis for the Brown cases, was alluded to earlier, and so many other civil rights cases that have existed. I think the importance, and what probably troubles me from a personal perspective, is what's really wrong with that language? Why is it so contentious that citizens would enjoy equal protection of rights? And I mean, you can escape into the legal language and the whole history of, well, state rights, and they're like countries and they're sovereigns. But the real truth of the matter is states were not only violating the rights of, at that time, freed slaves, they were all but terrorizing them. They were lynching them. They were taking property from them. They were not allowing them to do things on such a massive terroristic scale that I don't think any free country in the world would tolerate or think that that was a way in which the country should be. So why is it so offensive that we would want citizens to have equal protection of rights? I just can't figure that out from a practical perspective, but I understand that there are the arguments there, and we all like to engage in the academic side of it. But at some point in time, that question needs to be addressed.
Fascinating. Very powerful statement. You're so right to call attention to the centrality of the Privileges or Immunities Clause, which you'll hear more about on the second panel, which, as the judge said, was eviscerated in a case called the Slaughterhouse Cases, meaning that the Equal Protection Clause had to do all the work. Chris Coons, first of all, is a distinguished honorary visiting scholar at the National Constitution Center, along with Senator Mike Lee of Utah. We were also law school classmates, so I know how much Chris knows about the Constitution from our con law classes. Chris.
And you invited me nonetheless.
Exactly. Will you state the facts, please, of the slaughterhouse cases? Who was the plaintiff? And no, what I want you to talk about before we talk about current questions is, from your perspective, and the judge talked so powerfully about how important it was for Congress to enshrine this in the Constitution because majorities can pass. What John Bingham, the guy who drafted the amendment, and what were the other Reconstruction Republicans trying centrally to achieve?
So we've talked about due process. We've talked about the other provisions, but we haven't yet talked about one critical question that was answered in the 14th Amendment, which was birthright citizenship. I recently had the chance to take my whole staff on an early morning tour of the new Smithsonian Museum of African American History and Culture. And as you go from the very bottom floor up through floor after floor, gallery after gallery of the deeply painful, violent history of race, slavery, the Civil War, and the Reconstruction, it is a bracing reminder of just how bitter this history is in the United States and how central it was after the Civil War to amend the Constitution to clarify that freed slaves, that African Americans in this country were citizens and were entitled to the rights of citizenship. When you take the equal protection due process clauses and allow them to work and to take all the grand visions and ideas behind the Bill of Rights and then through the states apply them, you can ultimately see a pathway towards the progress that was accomplished nearly a century after Reconstruction through the Civil Rights Movement. But if you didn't have the foundation of identifying all Americans as citizens after this great rending experience of the Civil War, after slavery was ended, you wouldn't have the foundation on which you could then use due process and equal protection clauses. So I think now we perhaps have done a quick survey of all the core elements of the 14th Amendment, but it's also, if I could just make a brief comment after this election, important to remember that Reconstruction was a period of significant progress in terms of the opportunity for African Americans to hold elected office, to own property, to participate in civil society, to have standing in courts. And as Reconstruction ended, a campaign of terrorism and of the stripping of those rights and freedoms began that frankly largely lasted for a century and wasn't undone until the 1960s. But the great history of the 14th Amendment of the Second Founding, which I'm so pleased that all of you are celebrating and that we are recognizing, was that it laid the legal framework and the foundation that could ultimately be used decades later to make real the promise embedded in the foundational documents of our country. It's remarkable to be having this conversation literally in the building where those documents reside, and in a capital city where most of these key decisions were made. But a day does not go by when I don't reflect on the fact that I go to work in a capital that was built by slaves, where some of the greatest, most soaring principles ever enunciated in human history about liberty were sort of delivered and made real, but where the very foundations of it were compromised from the beginning by the experience of slaveholding founders and by the experience of a capital having been built by slaves. It is the foundational sin of our nation. In Lincoln's second inaugural, he very movingly talked about how, in some ways, you could view the blood and the loss of the Civil War as our penance for that sin. The 14th Amendment was our constitutional effort at repairing the fabric of the American promise in response to this great cataclysm of the Civil War to rid us of this sin. But the ultimate removal of that stain was not made real for more than a century, and as the Smithsonian makes clear, hasn't yet fully been achieved even today.
Wow, that was extraordinarily eloquent and a beautiful statement. I can't.
My former classmate is deeply surprised.
No. Why? What have you been taking, man? That was really perfectly stated. And I can't do better than just note, as Chris did, amazing to be in this building where the promise of equality that's in Jefferson's Declaration, which you can see here, implicit but betrayed in the Constitution, promised by Lincoln of the new birth of freedom, and finally codified in the Constitution in the 14th Amendment, which you can also see here, makes this second founding initiative so meaningful. And thank you also for noting how moving the African American History Museum is. The archivist and I just had the chance to see it on Monday, and it is an extraordinary addition to our nation's commemoration of the second founding. So, Judge, we now have a lot of ground to cover, and what I want to talk about now is segregation, and the fact that soon after the 14th Amendment is passed, the Supreme Court eviscerates it, not only in the slaughterhouse cases, which read the Privileges or Immunities Clause out of existence, but also in the civil rights cases of 1880, which strike down the Civil Rights Act of 1875, which would have guaranteed equality of public accommodations. And then we have Plessy versus Ferguson in 1896, which says that segregation on railroads is consistent with the 14th Amendment. And as Chris said so eloquently, it took a century and the civil rights movement to lead the Supreme Court in 1954 to strike down school desegregation in Brown versus Board of Education. You've written so powerfully about that story. Why did the court initially deny that the 14th Amendment forbade segregation, and what is the story of Brown that allowed it to reverse itself?
Well, Jeff, let's recall that, as much as we'd like to say the radical Republicans or the moderate Republicans had the truest of nature, of course, much of their impetus was ensure that their numbers would not decrease, or at least their numbers in the South would not increase out of the disproportionately, because the 3/5 clause at that time, by virtue of giving slave citizenship, they now were being counted as one. So then you had, and I bring that up because when you think of it in the context of, well, this is occurring, and you have these various factions. You have the radical Republicans, the moderate Republicans moving toward rights for African Americans to ensure that they can vote and to ensure they're not being disenfranchised in the process of it. And you've got the President of the United States, unfortunately, Lincoln is shot. And that is a very significant event, because then we end up with Andrew Johnson. Some have said the third worst president out there. I didn't say that, but it's been said. And
I won't ask you about the first two.
He had an agenda. He had an agenda in of itself, and the courts did not help it at all. As you pointed out, first they just read out the privilege and immunity, and not many scholars out there can defend that in the slaughterhouse case, and yet the Supreme Court allows it to go on, maybe because it's been going on for so long. And then you've got the cases that come up in the latter part of the 1800s, and that leads up to a 7-1 decision in Plessy versus Ferguson. And, at that point in time, you've got a very hostile court that exists. I mean, how do you get a case like Dred Scott to come out of the Supreme Court? That lets you know they're just pure racists. I don't know another word to say it. And at that time, it wasn't as pejorative of a term as it is now to say someone was racist. I mean, now to call someone racist is the worst thing in the world. But then it probably was not the worst thing to say that someone was racist. They were just racist. And some of them, I would say. And that prevailed in terms of the final decisions of the Supreme Court. And then along comes a man that I always mention when you mention segregation and you talk about Brown case. Anybody that knows anything about that will always bring up Charles Hamilton Houston's name, because that began the whole process of using the legal system and stare decisis and building up these precedential cases. Don't start first with the elementary kids, because nobody will win those cases initially. Start high with the graduate schools and then move eventually with cases that went through the system for 20, 30 years before Brown actually. So Brown actually was, some say sociological engineered. The case itself was engineered, no question about it. And it was engineered by using this equal protection type language. And even though ultimately the Brown case, many will say it probably turned more on a sociological basis than it did on the Constitution. There are those who argue that, but I think its basis is clearly within the Equal Protection Clause.
Chris, Brown was a series of cases, 5 cases, and one of them was from Delaware. Tell us about that dimension of it.
Well, ironically, there's important history in Delaware. Delaware was a border state. It was a state that had a strong Quaker community in Wilmington. There were very active abolitionists literally from the founding of the state, but a southern part that was slaveholding and part of the kind of eastern plantation economy of eastern Maryland. So Delaware as a state was divided in terms of its racial history and its politics, literally from its founding. We had in the tiny little town where I grew up of about 1,500 people, a so-called colored school, number 7, where parents of one of the children sued, saying that it was unjust that a school bus went literally right by their house to take white children to a nice, well-appointed, well-equipped school, and yet their children had to walk to this school, which was much smaller, much less well-equipped. There was both Beulah versus Gephardt and Gephardt versus Bolton, 2 different cases. One of the initial cases was about the integration of the University of Delaware, and then the next case was about the integration of the public schools in Delaware. And in both cases, if memory serves, Colin Seitz, who was a very young judge, issued what was a fairly landmark decision for Delaware. Many of us are proud of the fact that of the 5 cases that were gathered up into Brown versus Board, 4 were overturned because they were continuations of the Plessy line, and 1 was affirmed, and it was the Delaware case. Delaware, nonetheless, took quite a while to actually act on ending all school desegregation. Federally court-ordered busing was the case in the suburban county where I grew up for, I think, 18 years, and one of the few very broad sort of Mecklenburg County line analysis cases. And that's because the court found that there was intentional racist action by legislators to incentivize the segregation of the school districts between the city of Wilmington and the suburbs. So it was very broad, important federal court intervention in the 1970s and 80s in order to finally fully remedy what was the painful, shameful legacy of intentional school segregation in Delaware. A landmark case, but then it took really far too long for action by our communities to ultimately remedy that.
Fascinating. I want to ask you more about the reaction to Brown and take us up to the present, but let's just take one more beat on the reasoning of Brown. Judge, you said that some say that it's based on sociological jurisprudence. You're referring to the famous footnote in Brown that cited Kenneth Clark's Dahl studies suggesting that African Americans who'd grown up in segregated schools were likely to have a lower self-image than whites, and that was questioned. But Brown has also been defended on the grounds that the framers of the 14th Amendment intended to forbid any laws that affirmed a racial caste system. On the other hand, there were people who stood up in Congress when it was proposed and said, don't worry, this isn't going to apply to segregated schools. I had the honor and the great pleasure of having a dinner with the late Justice Scalia a few years ago, and I basically said to him, I screwed up my courage, I guess I'd had a glass of wine or two, and I said, hey, Justice Scalia, you know, all the historians, liberal and conservative, agree that Brown is inconsistent with the original understanding of the 14th Amendment. And he thought for a second, and then he threw back his head and laughed and said, well, you know what, no theory is perfect. So what I want you to do, Judge, is tell us why Brown was correctly decided. Explain to the audience, not all of whom are constitutional lawyers, why the 14th Amendment forbids school segregation and why the court was right to hold that way.
Well, I think the sociological data from the Brandeis, so-called Brandeis briefs informed the court's decision. I mean, it actually was a couple of decisions, and then they sent back, of course, Dr. John Hope Franklin and others who became involved in terms of the history of the 14th Amendment to try to find out the intent of it. But in doing so, the whole purpose of the Equal Protection Clause is to protect individual rights, from being infringed upon, and it just falls squarely there when you have the clear evidence that even when you have a segregated type society, that this whole business of being separate and equal just does not exist. You talk about the Delaware case, but in all of these cases, one of the things that the plaintiffs ensured was that the school systems that were in place, particularly one in Kansas, I would say, was in fact an equal school system in terms of funding of money, and equal in terms of a lot of things. They wanted to take that issue off of the table, because the remedy typically in these cases would be, well, if they are not being adequately funded, we'll send more money. Or if you don't have enough textbooks, we'll give more textbooks. So the idea there was to ensure that the children who went to these schools, and this is where I think Dr. Kenneth Clark's testimony came in most importantly, was to show that this whole stigma, this whole existence of being a subclass citizen going to a different school than other students, and then the opportunities not being existent for them, led to the whole pronouncement, I think correctly so, that this was an equal protection, that being that the Privilege and Immunities Clause is not there and that you don't have any other basis for it, but the Equal Protection Clause provided that whole basis. Let me just add one thing that I say I look at in terms of just in terms of how remarkably well-written this amendment is, and of course it was intended to be even more if you'd had Bingham to have his way about it. But one of the things that I find most curious, and I invite the Senate to address this, maybe to think about it, I don't think there's a chance in the world that amendment would pass today if you put it out to the states. That's my opinion. Hopefully you have a different opinion of that, Senator, but I don't think so.
Would the 14th Amendment pass, and then tell us more about what happened after Brown, what happened in Delaware? So fascinating that there was intentional segregation right in Delaware, and then sort of take us up through the equality debates of the 80s and 90s.
I'm going to take the challenge proffered by the judge. I'm simply going to say this as an observation. The Voting Rights Act of 1965 was adopted swiftly after a very important march co-led by now Congressman John Lewis, where nationally televised brutal beatings by law enforcement officers and deputized citizens of peaceful marchers, black and white, faith leaders, people from all over the country and people from the community of Selma, galvanized the country and its elected representatives to recognize that this ongoing racial segregated society was only kept that way through force that bordered on terrorism. That Voting Rights Act, for decades, guaranteed equal access to the ballot box and reshaped in some important ways the Congress for much of the next decades. And the Voting Rights Act was routinely reauthorized, readopted by Congress, often with no hearings or debate or discussion, usually by broad bipartisan margins. After a relatively recent case, Shelby County eviscerated one of the key protective provisions in the Voting Rights Act that provides for pre-clearance by the Department of Justice. A number of us got to work trying to take up the challenge issued by the Supreme Court, essentially, and modernize and update the studies and the analysis and reintroduce the mechanism of pre-clearance, but based on modern analysis of voting rights violations. Despite determined and deliberate and repeat requests, we could only find one currently serving Republican senator who would join with Democrats in co-sponsoring the Voting Rights Restoration Act. This has been hotly debated. I don't mean to drag us into the partisan issue, but on the question of whether the 14th Amendment would be readopted today, I don't know. But something that was as foundational to continuing to give life to what the 14th Amendment was all about and what it means. Finding bipartisan support for a way to keep the Voting Rights Act of 1965 vibrant and relevant for the whole country. We came up with a formula that no longer only focused narrowly on southern states and was no longer based on voting practices and discrimination that was decades old, but was modernized and relevant and was a formula under which other states, northern states, western states, could possibly be subject to those restrictions. And we could not find two on the other side of the aisle willing to take it up. That, to me, was a striking repudiation of what was previously a proud legacy of the Republican Party, of always being the party that was at the table for civil rights discussions and was often at the forefront of moving forward civil rights for decades previously. I think there are several other instances in my 6 years in the Senate where there have not been the kinds of bipartisan commitments to due process and to equal protection that have characterized the previous century. And it's my real hope that current and future leaders of the Republican Party will reclaim their historic legacy as a party that advocated for individual liberty as enshrined in the 14th Amendment.
Powerfully stated. Of course, the Voting Rights Reauthorization Act of 2006 was passed by overwhelming bipartisan majorities and signed by President George W. Bush, so that bipartisan tradition would be great to continue. Judge, the senator has mentioned voting rights, and we know that the 14th Amendment was not intended to protect voting rights. We know that because the infamous Section 2 of the 14th Amendment says, hey, southern states, if you deny African Americans the right to vote, as we acknowledge that you have the power to do, then you're going to have to suffer a corresponding diminution in your apportionment. And it took the 15th Amendment, whose second founding we'll celebrate in just a few years, to guarantee equality and voting rights. You've thought a lot about the 15th Amendment. You said in many ways it's one of the most important of the second founding trio. Tell us about its contemporary legacy, the Shelby County case that the senator mentioned, and the status of the way that the right to vote is being protected by the Constitution today.
Well, Jeff, you do know I'm a sitting judge at this time, so there are certain subjects I'm not going to get so deep into for obvious reasons, but I can say generally that the whole one thing you have to keep in mind is the Constitution, to my knowledge, and you got scholars who can tell you differently, does not really convey a right to vote. That does just not exist in the Constitution. It is a right not to be discriminated against in the process of voting. And that's where the Equal Protection Clause comes in. That's where due process comes in the process of analyzing if you're going to allow individuals to vote, you cannot do so in a discriminatory way. And that's where the voting rights process comes in, is that you get certain classifications of citizens, race being one of them. You clearly, I think most of us would agree, that ought not be a basis for you to determine voting patterns or to use it in any way to discriminate against that particular class. So I think it all comes down to a very simplistic, I say simplistic, it's simplistic, but it's complicated in terms of the way it actually is practiced. But a simplistic way of looking at it is to say you just simply cannot use that classification of citizens as a basis for determining voting districts or voting segments on it, and most people agree with that.
Senator, the 14th Amendment is the centerpiece of all of our most hotly contested constitutional controversies, as we'll hear about in the next panel. The court has extended the amendment beyond its original purpose of protecting African Americans to protect women, and most recently gays and lesbians, and recognizing marriage equality. Is that a betrayal of the original understanding of the amendment, or is it true to it, and in what ways is the amendment continuing to evolve?
I mean, I think it's true to it. I think it's true to its, in my view, core purpose to take the Bill of Rights and these very broad conceptions of individual rights and of liberty and incorporates them and makes them real and makes them effective in the way that we live in our communities and our states. And although the context of the time at which it was proposed, adopted, and ratified was one where this searing experience of the Civil War, principally about slavery and the ending of slavery, was the core animating concern of the adoption of the amendment. In my view, it was really the second founding of our country in that it took the whole concept of individual liberty, the balance between the government, whether federal or state, and the individual, and reset the table. So, I don't view the Obergefell's decision, for example, as some big violation of the 14th Amendment. I view it as a completely logical extension and continuation of the concept that due process and the opportunity for each of us to practice in our own ways, our own lives, is something that the 14th Amendment has now extended to the states, and that there are so many different ways in which it is the guarantor of our fundamental liberties.
Judge, another of the most hotly contested 14th Amendment questions is the status of affirmative action. And those cases pit justices who have two very different views of the meaning of the 14th Amendment. On the one hand, there are justices who say that the Constitution is colorblind and that any classifications on the basis of race have to be strictly scrutinized. On the other, there are justices who say that the amendment was intended to eliminate a racial caste system, and programs intended to help African Americans rather than to stigmatize them should be upheld. You're a sitting judge, I understand, but how should our audience choose among those competing visions? I guess if you want to tell us which one you think was right, that would be great. And how are these competing visions playing out in the courts today?
What I'd prefer to do is give you more of a general concept of what I believe in terms of the constitutional amendment itself and the provisions therein. Anytime a law is made, it is never made, I should say in very few instances, to deal with only specific instances in which the people who made it, that's exactly what they were thinking. And so then you go back and examine what were they thinking. Well, I can tell you, and everybody in here pretty much can agree, that if you go back originally, the individuals who made these amendments, even the radical Republicans, had certain notions and they had certain preconceived ideas that most likely are not being shared by the majority of Americans today. And so when we go back to look at it, we don't live in that world anymore. And just like when I write decisions, and quite often I'm writing for a specific case, but the precedential value of it may reach much further and in areas I didn't even think about as a judge in writing that case, and yet it applies. And because and in this instance, it should apply, the law should apply, because the equal protection of law allows for citizens to be treated the same, and you should not be treating people differently or discriminatorily. But in terms of the affirmative action reach, I don't think you can view it in a vacuum. You can't have a court system go from Plessy versus Ferguson to Brown versus Board of Education, and then even into the 60s, the 70s, and 80s, and finally starting to realize the true principles that the court said should have been there, and yet you've got nearly 100 years, or more than 50 plus years, of a discriminatory system that has been pervasive, and all of a sudden you says, okay, let's treat everybody equal. Even though you've treated a particular class of citizens in a particular way for generations. And when you have, just as in trying to ensure that we continue with the voting rights, if that's going to be done, the empirical evidence that's there, those are things that informs the court's decision as to whether it should be, if that evidence is actually there to show that disparity is within the system.
Wonderful. We're almost out of time. I'm going to ask you for brief closing statements, and the question is the obvious one. Chris, you've already answered it incredibly eloquently, but you did it so well, I want you to give it another crack. And that's basically, we heard the archivist say, Jack Rakoff says this is arguably the most important of all constitutional amendments. Why is the 14th Amendment important, and why should our audience care about it?
Well, the 14th Amendment is important because the concepts of justice, of due process, of sort of equal treatment of citizens is foundational to the nation that we've become, the nation that we hope to be, and a nation that inspires the rest of the world. We are a country that has gradually perfected its founding commitments, commitments that were flawed in some ways from the very beginning. But we are a nation whose steady progress towards being the kind of country of which all of us can and should be proud, and by which the entire world is inspired, has been uneven at times, but over the long term, steady. It's been said more than once by a number of famous people that the arc of history is long, but it bends towards justice. It is the 14th Amendment that is in many ways the most central piece of our constitutional architecture that ensures that in our legal system. A famous abolitionist once said that eternal vigilance is the price of liberty. And it is the 14th Amendment that really made a commitment by our country that liberty was at the long run going to win out, and that liberty equally accessible to people throughout our country would win out in the long run, and that liberty and justice for all really would someday become real in our society. Many in this country, after this tumultuous election, at a time when we are as divided as we've been politically since the Civil War, are questioning what our core commitments are and where we're headed. And I think rule of law, respect for these core commitments, and the place that the 14th Amendment has played in it are absolutely essential for us to retain our place as the world's nation, as the one nation in the world that is most committed to individual liberty and to the idea that we really can be a functioning democracy and one in which individuals and whole communities can achieve justice.
Beautiful. Judge Wynn, last word to you. Why is the 14th Amendment important, and why should our audience care about it?
Jeff, the Constitution as originally written had very lofty language in it. All men are created equal. I think through the 14th Amendment, we finally began to recognize and to accept that that Constitution actually means what it says. And the language that's used there in the aftermath of a civil war, 600,000 men or so died, and the countless women and children in the process of it, they died for something. And the war was fought for something. Slavery should never have existed in this country, but it did. And it did for a very long time. People prospered on it. Not only was the Capitol built, the very foundation of this nation rested upon the backs of black slaves who labored for years and years in one of the most oppressive forms of slavery ever in the world. You were actually born in it. You couldn't get out of it except in very, very strict type situations, and then could get back into it at any point in time. The 14th Amendment began to do those kinds of things. You know, I spent 30 years or more in the United States Navy as a JAG officer and retired as a captain. And I think about other countries and the kind of liberties that we fight for. We fought a Vietnam War, and this whole concept that we wanted individuals to have rights. We didn't. We wanted democracy to be there. The very concept of a democracy rests upon the fact that its citizens are treated with respect. They are treated in a way that is fair, that due process is something we all recognize, that the right to equal protection exists for every one of them. And so from that perspective, I think it's the heart of the Constitution, and it is the heart of this nation, the 14th Amendment, in terms of how we are looked upon by other nations and how ultimately we live with ourselves from day to day as a people, and we continue to, I think the word I would use is evolve, morally, spiritually, and from a legal perspective.
Wow. Ladies and gentlemen, please join me in thanking our eloquent panelists.
Thank you, Judge. What a pleasure. Great man.
That's work, man. That ain't something for me to do with you. Pleasure, Jeff. Thank you.
And now please join me in welcoming our next moderator, the spectacular Elizabeth Wydra and her dream team of 14th Amendment panelists. Thank you.
Thank you so much, Jeff, and thank you to that amazing panel of Judge Wynn and Senator Coons. It was so incredibly inspiring, and I am delighted to be following that up with truly a dream team of 14th Amendment lawyers. I think I would like to say that I would promise you a rich experience just from their words alone, but if you added up the billable hours value of this conversation we're going to have, you're definitely going to have a rich experience. As Jeff mentioned, My name is Elizabeth Wydra. I'm president of the Constitutional Accountability Center, and I'll just give a very brief introduction of our wonderful panelists because more information is in your program, and I know we want to get right to the discussion. So first, sitting next to me is Shannon Price Minter, legal director of the National Center for Lesbian Rights, one of the nation's leading advocacy organizations for lesbian, gay, bisexual, and transgender people, which has been advancing the civil and human rights of LGBTQ people and their families through litigation, legislation, policy, and public education since its founding in 1977. Next, Thomas Saenz, president and general counsel of the Mexican American Legal Defense and Education Fund, which is the nation's leading Latino legal civil rights organization, often described as the law firm of the Latino community. Apparently also a law school classmate of Jeff and Senator Coons. And speaking of law school classmates of Jeff, basically we're just having a law school reunion for Jeff is why we're all here. Dana Berliner, senior vice president and litigation director of the Institute for Justice, a libertarian civil liberties public interest law firm that has litigated over 200 cases, including 5 before the US Supreme Court. And finally, all the way down to my right, which I think is kind of, I guess maybe a description generally of our ideological balance, Alan Gura is the principal attorney at Gura, PLLC, which provides businesses, associations, and individuals with decisive representation before the US Supreme Court and federal courts of appeals. It's great to be with you all here tonight, and because I was trained as a textualist, I think it's important to talk about words. So I will read just a brief part of Section 1 of the 14th Amendment. It says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." These are broad, sweeping guarantees, and they were intentionally so. As we heard very eloquently from the first panel, they were written in the wake of a horrific civil war that removed the original sin of slavery from our nation's founding charter through the 13th Amendment. And the 14th Amendment was principally intended to bring our Constitution back in line with the great principles of the Declaration of Independence, which Judge Wynn so rightly said, really we're not truly in our Constitution for all people, all men are created equal, until the 14th Amendment. And the original 14th Amendment was intended, obviously, to ensure that racial discrimination would be prohibited, but the drafters of the 14th Amendment specifically rejected language that would only focus on racial discrimination and intended, rather, to have this broader protection of liberty. And so I'm so delighted to have here tonight folks who are litigating today in the courts that broader meaning of the 14th Amendment. Tom, I want to start with you because one of the broader applications of the 14th Amendment that was specifically discussed by the framers was national origin discrimination. They talked about children of immigrants. They also talked about immigrants. They wanted the protections of due process in particular to apply, as they said, to citizen or stranger. Can you talk a little bit more about the work that MALDEF does to protect the 14th Amendment's guarantees, particularly for the Mexican-American community, Latino community in the United States?
Well, certainly MALDEF and the Latino civil rights movement have their birth in the 14th Amendment when you look at the legal system, and that begins even prior to MALDEF's founding in 1968, begins with the Mendez case, which is a case that's gotten some attention recently and had a postage stamp in its commemoration, that was a school segregation case out of California that did not make it to the Supreme Court because the Ninth Circuit Court of Appeals, applying the 14th Amendment, concluded that that segregation, a separate and clearly unequal system, could not be sustained in California. And it continued with the first major case on behalf of Latino civil rights to go to the Supreme Court in 1954, the same year, and indeed decided the same month as Brown versus Board of Education, another unanimous decision by the Warren Court that rejected jury exclusion in Texas, a case called Hernandez versus Texas, where the state of Texas tried to argue that Latinos, despite the history that you've described, should be treated differently from African Americans when it came to jury exclusion. They did that by carefully categorizing Mexican Americans as white and arguing that because this was not discrimination between two races, but rather within the white race, that a precedent on jury exclusion that applied to the African American community should not work in favor of the Latino community. It was a theory that was rejected by the Warren Court unanimously. That then leads to many of the civil rights victories of the Latino community. I'm proud to say that my organization, MALDEF, has been at the center of most of those, including one that I would particularly mention because of the history that you've described, the case of Plyler versus Doe, which is a 1982 Supreme Court decision where the court concluded that applying a rational basis, or perhaps some heightened form of rational basis review, concluded that the state of Texas could not deter attendance in public school of undocumented children by what they had sought to do, which was to deny funding for undocumented students who were enrolled in public school. In essence, the court guaranteed access, regardless of immigration status, to public school from kindergarten through 12th grade, a very important rational basis precedent under the Equal Protection Clause, and the core, I think, of continuing to protect the rights of immigrants today, Latino immigrants in particular. It's interesting how the 14th Amendment had that important role in the commencement of Latino civil rights struggle, particularly in the legal system. It's somewhat evolved from there. We today spend more and more time using other claims. I used to regularly make speeches to law schools talking about how they needed to have a broader conception of civil rights beyond just the 14th and First Amendment and look at structural protections like, in particular, the Supremacy Clause, because so many of the successful challenges to anti-immigrant state laws, whether you go back to Proposition 187 in California in the 1990s or more recently SB 1070 out of Arizona and the states that followed, the basis of challenging those laws that to many appeared to be discriminatory, both on the basis of national origin and certainly on the basis of immigration or alienage, but the successful claims have been Supremacy Clause claims grounded in the clear constitutional principle that only the federal government has the right to regulate immigration in this country. But we are now shifting, even though I've given those speeches, broad conception, still believe in broad conception of all constitutional clauses with respect to civil rights, but we're now sort of turning a corner and using rational basis, equal protection challenges to some of those laws as well. And I'm going to be candid. Part of that is to ensure that we have access to fee shifting that you can get under the 14th Amendment that you cannot get under the Supremacy Clause. So if we want to continue, and by we I mean not just MALDEF, but many of our sister civil rights organizations, we want to continue to do this good work, we've got to try to collect fees from the other side. And under a 14th Amendment claim, you're going to get the fees, not going to get them under a Supremacy Clause. So we are more and more using equal protection challenges, applying rational basis standard, and prevailing in some of the anti-immigrant distinctions that states and localities have drawn.
You know, I think it's interesting that you mentioned the Supremacy Clause because one of the most important parts of the 14th Amendment is not just the actual guarantees that are in that amendment, but also that it ensured that states could not infringe fundamental liberties. Prior to the 14th Amendment, I think a lot of Americans are surprised to know that the Bill of Rights, which we so cherish, were limitations on the federal government, but the states were free to innovate in their restrictions on fundamental rights and liberties. And so the importance of the 14th Amendment in applying the Bill of Rights to state laws as well is incredibly important. And I feel like I have to go to Alan with that because one of the ways in which the drafters of the 14th Amendment intended to ensure that states protected fundamental liberties was through that language that I read just a moment ago that said that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Alan, can you talk a little bit more about that clause and your work litigating the Privileges or Immunities Clause, which I will say the Constitutional Accountability Center had the pleasure of working with you on that as well.
And it was wonderful working with you, Elizabeth, in that case, and you guys put together a fantastic brief for a who's who of the top constitutional scholars of the nation. And in fact, as it turned out, that argument turned out to be the decisive one. The court was split in various ways. And I must say that one of the most shocking things that we learned in 2010 when I litigated this before the Supreme Court is that all this time, since the ratification of the 14th Amendment, we still don't have a majority on the Supreme Court that can agree as to how exactly the 14th Amendment protects your rights against encroachments by your state and local governments. The justices were all over the map in terms of figuring out how exactly this language functions. But I don't believe that the framers of the 14th Amendment were very confused. The language was not picked at random. The term privileges or immunities had a very well understood meaning. It was well understood by judges at the time, at least until the Supreme Court found a new interpretation in the slaughterhouse cases. It was understood by the Congress, and it was understood by the people who debated the 14th Amendment when it was sent out for ratification among the states. And here's what it meant. The privileges or immunities of citizenship were those rights that were thought to be the natural rights that any free and decent government would guarantee its citizens. Some of those rights were spelled out in the Bill of Rights, but not all of them were. They were given some description in an earlier case from the 1820s called Corfield versus Coriell, which examined that language as it's used in Article 4, Section 2, which guarantees that no state is going to violate the privileges or immunities of citizens of other states. It's thought of as a comity clause. That is, if a state respects certain rights of its citizens, it can't then discriminate against visitors who come within its borders.
And that's comedy,
Comedy, yes.
C-O-M-I-T-Y. It's
I-T-Y,
not
that's right.
generally very funny. but,
Yeah, not ha-ha comedy. But nonetheless, the abolitionists and the North looked at that language, that expansive guarantee of liberty that was understood to be within the term privileges or immunities, and they said, we want that for everyone, and we want that as an original directive upon the states, so they could no longer continue to do all the various things that they were doing to people before, during, and after the Civil War. And again, some of those rights were spelled out in the Bill of Rights, not all of them were. And it's important to recount just a few of the examples of what bothered people before, during, and after the Civil War. First, we had some things that were spelled out in the Constitution. For example, the First Amendment, we all know, guarantees the right of free speech. Yet the South was searching the mails, looking for abolitionist tracts to burn. North Carolina prescribed the death penalty for anyone who published a book that advocated for abolition. The Second Amendment, obviously, was understood at the time. I know people debate this, but it was understood at the time to guarantee a right to keep and bear arms. Yet, obviously, in the wake of the Civil War, the South was disarming and then terrorizing the freedmen and their supporters. So again, enumerated rights that were being violated, but also some unenumerated rights that were thought to be very important. For example, the right to travel. If you were a free African American and you were a sailor in Boston, that was great until your ship landed in Savannah, Georgia, and then you had some problems. That's something that people were aware of. We wanted the right of people to travel freely across the country. And of course, we wanted certain basic economic and property rights, because slavery was not just a social evil, it was an economic system that compelled people to work and then stole their labor and gave it the value of their work to somebody else. And when the South was compelled to get rid of slavery, it nonetheless wanted to continue the institution in all but name. So the freedmen were compelled to stay on the plantation. They weren't allowed to travel. They were compelled to enter into odious contracts with their former masters and so on. And so there was a feeling among the Congress, the radical Congress, after the Civil War, that the Civil Rights Act should protect what? The right to make and enforce contract, the right to bargain for one's labor, the right to travel and learn about other work opportunities. People should be free in sort of the basic progress of their lives. Unfortunately, the Supreme Court did not always protect those rights. In the wake of the Civil War, the very first case that the Supreme Court gets under the 14th Amendment, the slaughterhouse cases, the Supreme Court comes up with a very funny view of what privileges or immunities might be. They say that, well, the only privileges or immunities that are protected here are those that arise from the formation of the United States itself. So, for example, you have the right to visit the Treasury building in Washington, and you have the right to the Navy's protection on the high seas, because we all know that the Civil War was fought because Arkansas was sinking people on the high seas, right? But as far as those basic natural important rights that we all thought were at issue in the Civil War and that were really at issue in the society, like your right to speak, your right to worship, your right to be free of searches and seizures that are unreasonable, and so on. Well, those are natural and pre-existing rights, and therefore those are not protected. And so we lost virtually the entire guarantee as an original matter of what the 14th Amendment was supposed to protect. And then the court embarks upon a process where for decades and decades, every once in a while, a right is litigated. It goes to the Supreme Court, and the Supreme Court decides whether or not this right is important enough, whether it's implicit in the concept of ordered liberty. They have all kinds of terms and tests. As they decide whether or not that right should be incorporated against the states through the Due Process Clause. Most of the Bill of Rights gets through, not all of it, though. There are some clauses out there that the court has rejected, are just not important enough, and you don't actually get to enjoy them as against state and local governments. Fast forward to 2008, the Supreme Court confirms that the Second Amendment guarantees a meaningful individual right to keep and bear arms. But the Second Amendment, it works in this town. The D.C. is a federal enclave, but it doesn't apply to state and local governments. The natural question then becomes, what do we do about state and local gun laws? Because, of course, gun laws, like all other kinds of laws, exist primarily at the state and local level. And so this gets litigated. It gets to the Supreme Court in McDonald versus City of Chicago. And I take it upon myself to argue not just the standard due process incorporation theory that had been sort of the accepted view, under which it seems fairly obvious if you follow the various elements of it, the Second Amendment should be incorporated against the states, but also having just litigated Heller, a case that dealt with the original public meaning of the text of the Constitution, I figured, let's talk about the Privilege of Immunities Clause. Maybe it's time to overrule Slaughterhouse, and of course, lurking behind this is also just the practical nuts and bolts strategy. I'm aware that not every justice on the Supreme Court is a fan of substantive due process, and it's particularly the more right-wing, conservative-type justices who don't believe in substantive due process, but they believe in originalism. They believe in looking to the original meaning and text of the Constitution. And at the end of the day, the Privilege of Immunities argument is the one that saves the day. It's the one that saves the case, because we have 4 votes by 4 justices who believe that for better or worse, like it or not, we're stuck with this substantive due process regime. We'll use it and incorporate the Second Amendment. We have 4 justices who don't think the Second Amendment is very important. They don't believe Heller was decided correctly, and they refuse to go along. And it's up to Justice Thomas, who holds that he will never, ever, ever go along with substantive due process. He simply cannot abide that. But he writes eloquently and quite movingly about the original promise of the 14th Amendment, what these words actually meant, what they meant to the framers of that document, and in a case involving Otis McDonald, the grandson of slaves, winds up saying that the Privilege of Immunities Clause is the one that's going to transmit this particular right as against the City of Chicago. And that's how we win 4+1 against 4.
And I think that, you know, it's a fascinating example of using original understanding of the Constitution to win a very hotly debated, whether you come out, whichever side you come out on, the gun control issue and the right to keep and bear arms, you know, using that constitutional history in order to win that debate. You know, I think probably one of the most important cases of the recent Supreme Court cases on the 14th Amendment that all of us know about is probably the Obergefell decision, which established the national right to marriage equality. Shannon, I'd love if you could talk a little bit more about how NCLR and you and those also in the LGBTQ advocacy community are using the 14th Amendment and its guarantees of equality in that context today.
Yeah, no, absolutely. I mean, the 14th Amendment has been the foundation for efforts to achieve equality for LGBT people in Obergefell and before. And Alan, your mention of the right to travel definitely caught my ear. There's a footnote to Obergefell and the cases leading up to it, and particularly the Tennessee case where my organization was counsel, and that was one of the 4 cases that was consolidated before the Supreme Court in Obergefell. We had argued very vigorously that denying recognition to couples who married in one state and then moved to another state and would find themselves suddenly unmarried, which was the case for all of the couples, the plaintiff couples in the Tennessee case, that in addition to violating due process and equal protection, that it also violated the fundamental right to travel. Now, that did not end up being an express claim in Obergefell, but I do think it was an important theme. And if you go back and read the decision, I think the court was very struck by the unfairness of couples suddenly being stripped of their marital status just by crossing a state line, and it really contradicts, the fundamental premise that we're one nation, one people living under one constitution. But look, the LGBT movement has been the direct beneficiary and depended almost entirely on our ability to successfully litigate constitutional rights for our community on the prior accomplishments and advocacy and jurisprudence of the Black civil rights movement, of the women's movement, of the disability rights movement, the immigrants' rights movement. Plyler's been a very important case in our litigation efforts as well. And every single U.S. Supreme Court case that has struck down some form of official discrimination against LGBT people has been squarely founded on the 14th Amendment, starting from Romer versus Evans in 1996 was the first time the court ever held that gay people in that case were a cognizable class under equal protection, and struck down a Colorado constitutional amendment that would have excluded gay people from any ability to ever get any sort of anti-discrimination protections from any branch of the state government. And then in 2003, the court, that was purely equal protection. In 2003, the court struck down state laws that criminalized same-sex intimacy in the Lawrence case. The court there relied on due process and, again, very much relying on the reproductive rights cases in particular. It said that liberty has a substantive element, and that includes the right to enter into an intimate relationship outside of marriage, and struck down the Texas so-called homosexual conduct law. And then fast forward to 2012 with the Windsor case, where the court struck down the Federal Defense of Marriage Act, which denied any sort of federal recognition to same-sex couples who had married under state laws. And there the court, through the Fifth Amendment, the application of the 14th Amendment through the Fifth Amendment, relied on both due process and equal protection to strike down DOMA. And then finally to Obergefell, where the court, again, pulling on both strands of the due process and equal protection, said that all state laws that denied same-sex couples the freedom to marry and denied recognition of their existing marriages violated both equal protection and due process, and reaffirmed that the freedom to marry is a fundamental right that's protected under the Due Process Clause, and reaffirmed as well that excluding an entire class of people, same-sex couples, in that case from such an important right violates the most fundamental requirement of equal protection. And I think not only was that case was so important, not just because marriage is important, because it really helped resituate LGBT people in our country. And as the court said, actually, you can trace the evolution of gay people and LGBT people more broadly from outlaws to outcasts to now being treated as equal, respected, participating members of the society. And that transformation has been so profound. And one of the things I'm most proud of, moved by, and being part of that whole trajectory is certainly what it's done for the LGBT community, but also I think the Obergefell decision is one of the most moving and profound reaffirmations of the importance and centrality of the 14th Amendment in our constitutional jurisprudence that has been decided in a long time, including, I think, the incredibly important insight that the court said new generations can see new dimensions of injustice. And it was the first time in a long time the court so unabashedly embraced the notion that the Constitution, the 14th Amendment in particular, is, as Judge Wynn said, an evolving, living principle, and that it can be and should be applied to new contexts. So I do think the decision is so important for that reason as well.
Absolutely. And before I talk with Dana for a moment, I want to note that we'll be going to questions in just a few moments. So think of your great questions for our esteemed panel and make your way to the microphones in the aisle in just a few minutes. Dana, we've been talking a lot about equality of rights, equal protection of the laws. IJ in your work does a lot on economic liberty. You represent entrepreneurs from casket makers to hair braiders. Can you talk a little bit more about the work that you do under the 14th Amendment, which I think a lot of folks, when they look at equal protection, they can see how that applies. Talk a little bit more about how you read the economic liberty concepts into the 14th Amendment.
Well, so the 14th Amendment, of course, we've been talking some about privileges or immunities, and we do attempt to litigate under the Privileges or Immunities Clause, but it's been eviscerated, so we lose under that. And we litigate about it to preserve it, to hopefully one day convince the Supreme Court that they were wrong in the slaughterhouse cases. But most of our cases focus more on the Due Process Clause, which does say that you cannot be deprived of your life, liberty, or property without due process of law. And that was, to go back to the history of the 14th Amendment, one of the major things that was going on in addition to slavery, as Alan said afterwards, were things like the Black Codes, later Jim Crow, but laws that prohibited freedmen from participating in trades, laws that required them to go through lengthy enslaved-like apprenticeship programs, laws that forbade them from entering into certain kinds of contracts, required them to get into other employment contracts, laws that forbade unemployment. There were all kinds of laws related to what kind of occupation you could engage in. And part of what they were trying to do with the 14th Amendment was to stop all of that and to allow the freedmen to actually choose their own jobs and work in them. And that desire for occupational freedom was a major part of what was the kind of origins of the 14th Amendment. So we primarily argue this under the Due Process Clause, although there are often, with the occupation, some sort of equal protection issue as well. But we argue it in not about discrimination amongst classes of people in the way that, that Tom and Shannon have been talking about. We argue that requiring an African hair braider to go through a year and a half of school in which you don't learn African hair braiding in order to be allowed to then practice your trade is a violation of the right to liberty is a taking of the right to liberty without due process of law. And so a lot of our cases are really about the rights to economic freedom, freedom to pursue the occupation of your choice without a state or local law that inhibits that in a way that makes no sense whatsoever. Now that has been labeled substantive due process, which is what the courts came up with to replace the Privileges or Immunities Clause once they got rid of it. It's sometimes treated as an equal protection question. The legal standards for these are all the same. What's, I think, very unfortunate is that the US Supreme Court in the 1930s decided that economic rights just weren't that important. And that's not the history of the 14th Amendment. They cared about economic rights. They cared about political rights. They cared about a lot of rights. And economic rights were some of them. But we're now faced with, Tom mentioned, what's called the rational basis test. For those who are not lawyers, the court has divided up our rights into 3 levels. Some get more protection, some get a middling amount, and some don't get a lot. And economic rights typically fall into that category, but we nonetheless litigate about that and seek to prove to the courts that people do have a right to economic liberty that is protected by the 14th Amendment, and that should not be violated.
Wonderful. We'll take your questions now. So if you could make sure to make your way to the mics on either side of the aisle so both we can hear you and your fellow audience members can hear you, and also those watching at home can hear you as well. So step right up and ask your questions all about the 14th Amendment. I have plenty, so don't let me hog the whole question and answer period. Yes, sir.
In one of the early cases involving the 14th Amendment, probably in the 1880s, it's my impression that the Supreme Court, out of nowhere, invented the doctrine of corporate personhood. I think one of the justices said, well, of course, everyone here agrees that corporations are included in the meaning of the word persons. And nobody on the court dissented, even though, as far as I know, that was a complete invention. There was nothing in the history of the 14th Amendment that talked to that. So in other words, corporations are people too. So that's I believe, is the origin of that. So I just want to know if anybody has any background on that decision.
Thank you so much for that question. Before I open it up to the panel, I would urge you and anyone else curious about this to read a wonderful publication by my colleague David Gans at the Constitutional Accountability Center called The Capitalist Joker. That's all about corporate personhood. You can find it on our website at www.theusconstitution.org. Would anyone like to talk about that? Yeah. Corporations are people too.
Well, I'm not sure the origin of the doctrine is in the 14th Amendment. I believe that there's a legal basis for it that extends beyond that, but it's not something I've studied at length.
Yeah, I think the idea is that there was a claim that the drafters of the 14th Amendment wanted to cover corporations. My colleague argues very compellingly that that it was slipping a capitalist joker into the deck of rights protected by the 14th Amendment. Obviously, other people argue that under other provisions
But I
of the
will say this, I
Constitution.
mean, many of your freedoms are not really worth a whole lot if you can't exercise them in the corporate form. I mean, if you talk about, we've had a lot of talk recently about the First Amendment. We have a president-elect who wants to open up the libel laws, and one of the problems he's facing is a case called New York Times versus Sullivan, which of course raised the standard under the First Amendment to sue people and hold them accountable under the libel laws. Well, that was the New York Times, a corporation, versus Sullivan. And if the New York Times doesn't enjoy the First Amendment's protection because it's a corporation, it's hard to see how any media entity could enjoy the benefits of the First Amendment, because very few people are going to operate their media empire as a sole proprietorship. We have legal mechanisms to interact with each other and to form businesses and to express ourselves and to conduct our lives, and oftentimes those take the corporate form. Attorneys oftentimes function as professional corporations, and sure enough, we wouldn't say that people don't have the right to counsel, they don't have the right to hire an attorney of their choice because the attorney is effectively governed by the state bar as a corporation. So I think it's an area that definitely is open for debate.
Yes, Tom.
So I just want to pivot a little bit. I think it's an important question. You've heard, I think from the prior panel and this one, that one of the things that's so distinctive about the 14th Amendment is that it is an evolving amendment over its history. It has changed to cover many, many different circumstances as they arise. And I think we have to pay attention to potential hierarchies, not just of rights as Dana has described, but the potential for hierarchies of rights holders and where that ought to be. And I would simply point out, because there's been so much discussion about privileges and immunities, that one thing textually that distinguishes it is that privileges and immunities, as you read, applies to citizens. Due process, equal protection is a guarantee to persons. Mm-hmm. And that is potentially of significance today, different significance even than it may have had when the amendment was adopted. And I think we have to attend to where the amendment may develop in the sense of hierarchies, potential hierarchies of rights holders, just as we've gotten to with respect to the rights themselves.
Thank you. Yes, sir.
Okay. Excuse me. I have two questions. The first one, I believe in Section 2 of the 14th Amendment, it talks about how electoral privileges can be taken away or due to acts of discrimination towards people in your state. So in this election, there were states who were found guilty of discriminating or taking the right to vote away due to people's ethnicity, racial background. And in plenty of those cases, they were overturned, but or they made adjustments or whatnot. So would it make sense to have an argument for this election that some of these states who tried to take the rights to vote or the accessibility to vote away from African Americans and other minorities, that their electoral college count should be reduced in like a next election cycle? Second question I have is, I think there's a like an alarming number of parallels to the issues happening today that were happening during the time of Reconstruction when the 14th Amendment came about. And I look at when Reconstruction ended, there was a greater emphasis to focus on issues of class and economy opposed to reshaping America along racial lines to allow equality. And I see that similar sentiment happening today. If that's replicating, and we know that there was about a 100-year delay in African Americans and other minorities reclaiming these rights, what kind of strategy do people have coming forward to make sure that we don't fall back into this class, economic-based argument, which precedent already shows inclines our society to disenfranchise minorities to an alarming degree? Thank you.
Thank you so much. Those are really great questions. I think particularly, we've talked about the parallels with Reconstruction earlier tonight, and would anyone like to take up, I think the voting issue is something important. I think MALDEF has been involved in the voting rights litigation.
Sure, I think it's a good and interesting question, how or whether that particular part of the amendment should apply to what's occurred today. I think the question, of course, refers to some voter ID provisions that courts have concluded were both intentionally designed to disenfranchise racial minorities and certainly had the effect of doing so. I think it's a conversation worth having. I'm not sure where it would go, but I think it's important to be a subject of discussion because even though ultimately in most cases those voter ID provisions were struck down prior to the election, what we did see were the lingering deterrent effects of laws that had been on the books, had been in the media, and where, in fact, some registrars and clerks inexplicably continue to advertise these laws as though they remained in effect. We saw that in Texas, and indeed, MALDEF intervened with respect to one county to get inaccurate posters taken down from early voting locations. I think when there is a demonstration, as there was in Texas, of intentional racial discrimination, and there are lingering effects from those laws, it's something we really have to attend to. I would just add that the best approach to that is the preventive one, and Senator Coons talked about the Voting Rights Advancement Act, which has been proposed as a solution to Shelby County and would help in addressing many of these concerns about implementation of laws that are ultimately held to be unlawful because they are discriminatory. Pre-clearance prevents them from ever being implemented until they are evaluated in what I would, I think, fairly characterized as an alternative dispute resolution system, which saves both sides money, but you prevent any of the deterrent effects from a law being in effect, even if it is then ultimately taken out of effect prior to the election.
I can address the second part just briefly. It's certainly true in what I was discussing about economic rights and economic liberty, that the effects of state and local laws that create barriers to entering into businesses typically fall hardest on people who have less resources to combat them. So for a person who is wealthy, spending a year in school and paying for that and not working, they can manage it. It's the people that actually need to be working who can't afford to waste a year in school that they don't need in order to enter into their chosen occupation. So those laws tend to fall hardest on the lower socioeconomic classes, the people who are trying to get up the economic ladder and can't because of the barriers that states and municipalities impose. And that is part of the promise of the 14th Amendment, is that states and localities won't be able to do that, that they can't take people's liberty away in that fashion.
So we have time for one more question. Yes, ma'am. No pressure.
I especially enjoyed your narratives in each of the areas that you care about of the case law that brought us here. And I'm wondering, going forward, if either because hard cases make bad law or because of precedents that are hard to overturn, what are the situations and the cases that keep you guys up at night? What are your nightmare cases in each of the areas that you care about? Is there anything that worries you?
Oh gosh, that is a great question. And I think, as we look at the future of the Supreme Court, which is a little bit unknown right now, I think a lot of us are kept up at night Shannon, there's an important transgender rights case before the Supreme Court this term. Do you want to talk a little bit about that and other things that you see on the horizon?
There is, and I'll just quickly say that at least as far as the freedom to marry for same-sex couples go, I'm not particularly worried because that decision was so recent and because the majority that issued that decision will remain intact even if the Justice Scalia is replaced by a justice who disagrees with the decisions in Windsor and Obergefell. I think stare decisis and the strength of those decisions means it'll be really hard to reverse them in the foreseeable future. Much more worried about, as the last questioner mentioned, the erosion of voting rights and protections under equal protection, the continued erosion of equal protections for black people and other racial minorities in this country. But yeah, there is right now in front of the Supreme Court a very important case, a case that for transgender people may be as important as Obergefell was for same-sex couples, that poses the question of whether Title IX, which prohibits sex discrimination in public schools, protects transgender students. That case is teed up. It will be fully briefed about middle of January and probably heard. Oral argument will be heard at sometime in the end of February, and how that case is decided could be of monumental importance for protections for transgender people across a whole broad array of federal sex discrimination statutes. So that's something of deep concern. I'm hopeful that that case will come out the right way, but it's extremely important.
Anyone else want to talk about your nightmare cases, or what are your dream cases? I always like to end on a positive note. You know, what is there that still inspires you about the 14th Amendment?
Well, I'm unfortunately going to be a little more pessimistic because I do want to respond to the question. I am concerned about how the court may deal with important questions of the rights of non-citizens, immigrants in whatever status there may be. We have not been good historically at applying equal protection or due process to immigrants. And so much of the experience of the Latino community throughout its history is of facing what to many, particularly in the Latino community, appears to be racial discrimination, but that is promoted under the guise of some proxy, whether that's immigration status or presumed immigration status or language or citizenship. And we've never been very good about that jurisprudentially, and I am concerned that so many issues in this upcoming administration, if the campaign is any indication, will end up before the court with an undeveloped or not well-developed sense of the 14th Amendment in its application to the rights of non-citizens.
Mm-hmm. So one of the issues that we litigate a lot is whether the desire of government to protect existing businesses from competition is a legitimate thing for the government to be legislating. These people are already in, let's keep out people who might compete with them. And there is what is called a circuit split on this issue, which means that some federal appellate courts go one way, some go the other way. So it is both my nightmare and my dream to get that split resolved favorably is the dream, to say that state and local governments, in fact, can't decide we like these people better than those people. These people get to keep their jobs. These people can't go into that occupation. That is, so that it's both. That's not up at the U.S. Supreme Court right now, but it's gonna go up there because there is this ongoing split. So that's what I worry about.
Well, I'll end on an optimistic note. I actually do believe we're going to get rid of the slaughterhouse cases. I'm not sure when that's going to happen.
Oh, Alan.
But it's going to happen, and I'll tell you why. Look, over the century plus that we've had this abomination in the U.S. reports, we've had more than 5 justices. I believe we've had 9 justices who've agreed with the correct original understanding of the 14th Amendment in this area. Unfortunately, we've not had more than 4 of them at any one particular time. But law students read these cases, and no serious person reads Slaughterhouse and can agree that it's correct. And even in McDonald, nobody said it was right. They just said, well, it's old, and so we're going to keep it. But it is an imperative to get rid of this, to give people the 14th Amendment that we were all intended to have. The issues that the Privileges and Immunities Clause was intended to address have not gone away. People are still suffering the denial of many core rights. There are not necessarily spelled out in the Bill of Rights, but that are still basic to the fabric of civil society and a free existence. And as the government becomes ever more intrusive into people's lives and everything gets overregulated, I think people are searching for an answer, and the 14th Amendment provides that answer. It tells states that they can't violate your privileges or immunities, and we know what those are. Those relate to your natural rights, which include not just everything in the Bill of Rights, but also certain core basic human rights that have been understood in the classical liberal vision over the centuries. And I think we're going to get that. It's just a matter of time. Perhaps we'll need some more justices, to be sure. We need at least 4 more right now. But we're, it's never too early to start asking nominees about these issues and to start getting them back into the conversation. So.
I think that in this moment there's a lot of debate about what our constitutional values are, what kind of country we are, what kind of country we want to be, and I think that the 14th Amendment, as we've discussed in both of our panels tonight, provide a lot of answers about what our constitutional values are, values of equality, liberty, inclusion, and so I think we're all grateful that we have this constitutional protection today and every day. And thank you so much to our panelists to talk about the way that you vindicate those rights in court. It's not just an old document, parchment that is irrelevant to your lives. It is deeply relevant to your lives every day. And thank you for making that so clear. Please join me in thanking our panelists. Thank you.